So I think one of the big questions generally people have with AI is my stuff automatically the property of a company like OpenAI if I've put it on the internet before? Can you talk through like what is the legal consideration around ownership if I've been writing blogs, for example, or I talk about my own methodology, whether I've patented it or not? What's the legal consideration of that becoming part of a LLM that I never necessarily gave consent to?
Yes, that's a big topic. So if you use the free ChatGPT version, the content you put into the GPT will be used to train future LLMs. And they state that up front. So the way to avoid that is to use the paid subscription service. The terms and conditions there state that they will not use your data for training purposes. Of course, the question that you have in your mind is whether or not you can trust that term and conditions from OpenAI, but that's the contract they have, is that they state that if you purchase the paid version, your content will never be used to train other LLMs.
What might the ramification be? Because a lot of tech companies say, we won't use your data, and then they use your data, and they're like, oops, we did it. So what kind of protection might a company have if they find out, or is there none, if they find out that maybe they've been using a paid version, or the terms and services say, we won't train our models based off your inputs, and that ultimately does happen?
I think in the end, you have to use legal recourse for that if you find out that they're improperly using your information. Now, OpenAI, at the beginning, they scraped from many sites, and that's why currently we have lawsuits from the New York Times and other news journals alleging that they used their content to train the initial version of the LLM. So all that is being resolved. I suspect that this is going to be something very similar to YouTube, where at the first generation of YouTube, there was a lot of piracy concerns. And then when Google acquired YouTube, they form a solution to address that. So I think right now, yes, there are some uncertainty, but I think as the industry matures, they will solve that problem and you will be protected because the industry cannot move forward if they abuse your trust. That's my feeling.
If you were on the leadership team at the New York Times, let's say you were the chief legal officer for the New York Times, is this something you would bother with? Would you advise them to fight OpenAI in court or find a way to create like a collaboration solution?
That way, they didn't get much money out of it. So, there was a lot of criticisms of the news organization putting their content onto Facebook and Meta, right? So I think those guys are now much more sophisticated, the news organizations. They're much more sophisticated and they want to claim their revenues. And so they're currently in court in New York against OpenAI on copyright issues. AI does want to resolve this uncertainty and move forward. And I think the news industry also want doing both. They're just trying to get a better deal.
If I were on the leadership team at a company like the New York Times, instead of taking OpenAI to court, I would actually be working with them to figure out how do we both benefit from AI, because it's not going away. It's only a losing battle. They're going to win in some way.
If I were at the leadership team in the magazines like the New York Times, I would work hard to negotiate with OpenAI and other LLM vendors a fair deal where I get my content exposed to the users via the large language models, and I get compensated nicely for that. And I think that's a win-win model because the large language machines can benefit in the accuracy of their answers, while the reporters and the newspapers and the magazines get compensated for their time in creating the content.
Now let's talk about the other side of AI, which is how can I protect, let's say I've come up with a certain way to prompt AI to get results I want to. Is there a way to legally protect that? And then the dovetail to that is, what is protectable in AI? Because in the past, it's been tough to say software itself is patentable.
So a prompt, it may be protectable under the copyright system. So if you have a series of prompts that achieve a particular objective, you can copyright those prompts. The issue is whether or not somebody has been exposed to those prompts, i.e., has access to those prompts before you can prove infringement. So in general, prompts are hard to protect unless you have a very specific prompt that does something really desirable. Like, let's say you sell a package of prompts to generate emails for a particular target, and that prompt is very powerful, and you have to use exactly those prompts in order to create a viral set of email. And then you sell a book with those or some sort of an online content that has those exact prompt. And let's say somebody bought prompt and then or benefited from those prompts, then you can pursue them, because now you can show that, hey, they have access to your material, they use it without paying you for the copyright that you have, and therefore they should pay you damages. But if they didn't have access to your prompt, they independently recreated that, then there's nothing you can do about it.
Now, there's a lot of, I think there's a race to being the company that has the most like vertical based moat for AI. So you're trying to acquire as much data as you can to, for example, be the go-to for generative AI in fitness, because you've got enough essentially like fitness data you've pushed into your own platform, as opposed to any data about anything. You're trying to basically build a moat against competition through just focusing on one specific vertical. What kind of, aside from just having a lot of data, are there any kind of legal protections that kind of company could take to further build that moat?
So sure, let's take the example of the healthcare of the fitness company, right? So you could have perhaps an app that collects data from the watches or wearable devices, and then make a recommendation to the user on how to practice, how to exercise, how to improve the exercise. So that would be patentable subject matter, and then your software can be patent pending. You can also brand it as a trademark, your software name and the business that you're operating in. I think the most powerful two solutions you can do would be patenting and to trademark the brand of the product.
Let's say you're trying to build a moat, an AI moat in a specific vertical. Let's take fitness, for example.
For example, fitness. You have 4 options here. First is patent, second is trademark, third is a copyright, and fourth is trade secret. And we will discuss the benefits and advantages of each. So patent is the most powerful because it covers all forms of software running your AI software. Trademark is also very powerful because if you become popular, let's say maybe Apple or Nike, when you say that word, people instantly know that it's quality. So trademark is very powerful for your product and the executable. But these days, people don't buy it. The fourth thing is trade secret. And so that certain things you want to keep a secret. So for example, on AI, how you train your neural network, that is really not patentable subject matter, but how you do it can be very important in making the solution run correctly. So the way I would architect it is consider the patenting of your software and trademarking of your branding. And those two, I think, will go a long way to protect your moat. The other two are important, but they're in a lower tier.
Just clearly explain patent versus trademark versus copyright versus trade secret, and when you would use one versus the other.
So in IP protection, there are 4 types of IP assets you can obtain for your work product. First is patent, and that covers inventions, machinery, software, things like that. Trademark protect your brand. So think of Nike, the brand for the shoe. Nike may also have patents protecting the operation of the shoe, right? Copyrights really protect the written work or an audio-visual recording. So for example, music would be protected under the copyright. Your rap songs, Rashid, would be protected there. If you write a book, it will be protected under copyright. Your source code for software would also be protected under the copyright system. The one downside of the copyright system is that somebody has to have access to your content and they copied it. So if they independently develop it, you don't really have a cause of action. And that's why patents are powerful. Let's say if you come out with a new widget that has A, B, and C features, somebody who's never seen you, if they do the widget with A, B, and C features, they infringe the patent, regardless of access or not. If they have seen your product and they've copied or not, that's irrelevant. And that's why patents are important. Right? Trade secret would be, well, of course, with the name, it has to be a secret, right? And it has to have value to you. And you've taken care to protect that secret. So you can't go off and claim a trade secret, a customer list, if you never bothered to protect them, right? So contrast, let's say Apple builds the spaceship building to shield their internal work from other people, and then you fly a helicopter over the building, observe what they do, and then you go off and you do the same thing. Then you would likely be violating the trade secret because Apple took care to protect those secrets, and then you trespass on that and you took that secret away from them, and then you benefit from that. And that's why I think Apple is famous for their secrecy. So those are the 4 regimes of IP protection. Patents, the most powerful. Trademark, also very powerful, because if you have a large following, you're well known and people can't just rub off from your name. Like, for example, the McDonald's symbol is very powerful. McDonald's will go after you if you use the McDonald's arch symbol, even in the shoe industry, outside of the business, because they're so well known and so distinctive. So it's powerful. Copyright, also powerful, but they're really applicable to content creators, such as, let's say, you are a musician, you are a movie production house, or you're an author. That's very powerful protection for your work. And then trade secret. Basically, you have to take protection for it. And the most famous trade secret is the Coke bottle formula. So those are 4 examples of IP assets that you could have in your company. There are 4 types of IP assets you can procure. First is patent, that covers mechanical objects, your software, your medical device, for example. Then we have trademark that cover the branding. So the famous McDonald's is the branding, and it's very valuable. Then we have copyright. Those cover, let's say, music, books, videos, and movies. And you've seen these everywhere. Then the final item is trade secret. And an example of a famous trade secret is the Kentucky Fried Chicken formula. No one has ever seen that or able to reproduce that. Or let's say the Coke formula. It's the same thing. It's a secret, very famous secret.
Okay, great. Do you want to talk a little bit about and maybe I have it wrong, I thought copyright only protects it in that instance,
Yes.
right?
So here's the important thing to understand about copywriting. It protects only the exact version or substantially similar version of your work product. Somebody else could go in, review your work product, and independently create another version. And so how far can they do this? Can they just lift one paragraph from a book of, let's say, 100 pages and be liable for copyright infringement? No. I think if it just lifted a small section of that, there is a doctrine called fair use would say, it's just insignificant amount of use. But let's say if it's a substantial amount of copying, almost everything there except that they just made minor changes here and there, that would constitute copying. For books, that's most commonly the problem. For music, I think there's a number of copyright lawsuits that deal with the topic is there, the verbiage is there, the music sounds almost there, and there's a lot of uncertainties in that music copywriting dispute.
A medical device or instrument, you can clearly point to and say, that's mine, right? And you can legally protect that. How do you do that for digital health solutions? So if you have a digital health solution, it's not the same as a medical device where you can point to and say, that's mine. So how do you protect what you have? Because it's still health.
For digital health solutions, What you can, they typically use software that gets data from, let's say, a wearable device or some remote blood pressure measurement device that you query it and retrieve the blood pressure information or the scale, for example. So you protect the software that resides on the mobile device or on whatever platform that you have your digital health running on. We would have a series of software flowchart that illustrate how your software operates. And, normally you would have to collect data from a hardware device. It could be a wristwatch with sensors in there that detects your heart rate. It could be an accelerometer that detects your motion. Then you do some sort of a processing, some software flowchart. Then you output something back to the user to say, hey, take action on X, Y, and Z. So that entire sequence of data capture, processing, and then outputting diagnostic messages to your user, those are all protectable under the patent system.
Let's build on that now so I'm wearing a Whoop. Have you heard of Whoop before?
Yes, I know them.
I'm also wearing an Apple Watch. How can both exist at the same time if they're both performance tracking devices?
So you just showed me two devices that perform the same function. The Whoop device basically is a downstream smartwatch without the display. The Apple device is a full-blown smartwatch that has, you can program it, you can have apps inside of it, and you can have displays, and it has also probably the same sensor that the Whoops have. Whoops has a lower cost advantage, whereas Apple has more functionality. And so the question then is, if there are a series of fundamental patents covering smartwatch, how is it that they both coexist? My guess is there are two possibilities. One is that Whoops, because they do a subset of full functionality that perhaps the Apple patents would not cover. The other possibility is that there's some sort of a cross-licensing arrangement between Whoops and Apple to deal with that. Because if you think that why would Apple enter a space without patents, right? So I'm sure they have a patent that covers the various aspects of the smartwatch. A third possibility is Whoops is implementing what is called the prior art, older technology that it's not quite a smartwatch, but they are just simply doing heart sensing. And so they're doing a subset of the features that basically has been done in the prior art, and those patents have expired, and that allowed Whoop to be in that space. So Rajiv, you are a health fitness fit when you have both Whoop and Apple smartwatch on your wrist. And the question is, how could they both exist? And I think that might be a question for all founders, right? If you're interested in doing another healthcare device on the wrist, how is it that you would coexist with, let's say, bigger companies that do general purpose smartwatches? So the Whoop device is a very specific device. It doesn't have a display. You can't text out of it. And meanwhile, the smartwatch, it has a display. Some smartwatches have cellular communications, a full-blown computer. So how would you coexist with the big companies with their patent portfolio? There are, in the case of Whoop, I think there are three scenarios. Number one, they may have licensed some patents from Apple in order to produce this. Number two, they may be, because of their functionality is so specific, they may be implementing some prior art patents that have expired. And then of course, they add some new things on top of that. But the fundamental device of a device that's connected to your wrist that has an LED sensor may already be in the prior art. And if they're doing that, they can avoid Apple's patent, right? And number three is related to that, is that Apple may have patents on a smartwatch, but those patents require a much more expansive set of claim elements. So for example, the Apple patents would likely require you to have a display and some sort of a Bluetooth and then some sort of a health sensor into that. And because of that requirement of having a display, it wouldn't cover a device that does not have a display. And it may be that Whoop purposely did it that way to avoid some patents out there. We don't know that, but those are my hypotheses as to how Whoop can coexist with Apple smartwatch. Those are very good questions, Rajiv. And so the answer is that there are multiple ways you can protect yourself, and I would recommend doing all of them so you have a belt and suspender protection. First, You can do a provisional patent application fairly inexpensively. You can do it yourself and file it with pay a small government filing fee, and you are patent pending. The provisional doesn't have any specific requirements, so you can put in a back of the envelope as a provisional application, or you can put in all your engineering note as a provisional application. My recommendation is you do something in between. The problem with a back of the envelope is that it's too high level and it's not going to support your ultimate regular patent application when it comes out, because a regular application is somewhere between 30 to 50 pages in length. And if you have a one-pager back of the envelope submission as a provisional, natural question is you don't have control of that idea when you file it, right? So you don't want them to be too skinny. On the other hand, you don't want to be submitting all your engineering source code and everything into there, because guess what? The provisional application, if you file a non-provisional from there, eventually open to the public, because that's a document that's used in supporting a patent, right? So you don't want to put everything in there because people can look at it and copy you. The answer is to do something in between where you show enough details that you can say, hey, any software programmer looking at this can implement it. Any hardware engineer looking at this can implement it. It's a requirement, is you need to teach somebody skilled in the art how to build. That's a high level statement, but I think my recommendation is you put something very similar to a contract statement of work, a high level statement of work, as a provisional application. Lawyers can do the provisional application fairly inexpensively too, so check with a lawyer to do that. So we talked about patent application. There's also a confidentiality agreement that you can use, and that will then give you both layers of protection, patents as well as a trade secret protection. And so I would recommend a belt and suspender approach to inexpensively protect your ideas before you go to a non-provisional patent application. If you're early in your entrepreneurial journey and you have an idea and you need to disclose that to, let's say, investors or your co-founder at a very early stage, and you don't have the money to go and do a full-blown patent protection, here are the things that you can take. So that question has two components. You sending them out and then they send them back in. And I'm just going to answer it from your perspective, right? Because there's two sides of it. They're going to send you an NDA and you're going to send an NDA, and you may not want to be, right. And yes, that's I think they should do that. Should you get an NDA signed before you have a meeting with somebody? So as all lawyers say, it depends, right? So if you are talking to a contractor or an employee, absolutely send the NDA out, because it'll give you belt and suspender approach. So even if you have a patent application, do use NDAs. Now, if you're dealing with an investor, you really don't want to be sending them an NDA. What you really should do is patent first, and then just talk to the investor at a high level about what your product is about. That way you will not look unsophisticated to a venture investor. Should you send an NDA out to someone before you have a meeting with them? Well, the answer is it depends. If you are talking to an angel investor or a venture capital investor, you don't want to do that, because they'll make you look like you're unsophisticated because they won't sign it. Now, if you're talking to a contractor, a manufacturer, or your employee, absolutely send out the NDA, because it will give you protection, even if you already have your patent application file already. Should you have an angel investor or a venture capitalist sign an NDA before you meet them? Well, the official answer is yes, but because of the power dynamics and the social aspects of this, you don't want to send out the NDA, because the investors will simply says, no, go talk to somebody else. And then in that case, you're stuck. So the better thing for you to do is not to ask for an NDA from your investors or your potential investors, but do a patent application in advance, and then you can talk frankly about it. So in around the year 2000, I was at a big law firm, and Invisalign back then was a startup company looking for their Series A. They finally raised their Series A with Kleiner Perkin, and a few months after that, they brought me in-house as their associate general counsel to continue the patent prosecution and to build a great patent portfolio for them. They expect to become a giant public company. So that was my very first exposure of jumping from a law firm and going into a startup. And the journey was a fantastic journey. I learned a lot. When I came in, the company was small, they were chaotic. They had different teams that did the software, the computer-aided design software that deals with the tooth movement. Another team dealt with the 3D scanning of the teeth. Another team dealt with the setting up of the 3D printing machine that created the positive of your teeth from the scan teeth model. At the time, was the largest 3D printed fabrication house in the world. They had over $20 million worth of 3D printing equipment there. So my journey there was very interesting. We organized all of that and we patented all aspects of the system, the diagnostic system, the treatment system, the 3D printing system. And over time, we evolved into handling different additional new aspects. So for example, initially, the way we get a digital model of your teeth was to get an impression using dentists. They take a bite of your teeth and then you clamp down and you'll come up with this negative model of your teeth. Then what happened is we take those negative models and we pour a positive into there and then we scan that layer. And initially it was done in a very expensive manner. And then we transformed that into putting that positive models into a CT scanner so that they can scan hundreds of them in one shot. And then, of course, once we have a CT scan, we can create a 3D model. And then the 3D model can then go into the computer-aided model so that you can manipulate the tooth movement. And that's how your teeth will be treated. There are other advances over the years. So instead of doing of your teeth, now they use what is called intraoral scanning, where essentially they're sticking in a camera or a laser set of beams, and then they can scan your teeth internally without doing the mold. So companies over time advance the technology. And so I was lucky to be a part of that startup sequence. Today, there are many companies that produce invisible braces or devices that can move your teeth. However, 20 years ago, a company called Align Technology pioneered all of this technique, and they were under patent protection for all those 20 years. And of course, as the patents expired, we have new entrants. So 20 years ago, they were at the forefront of this technology, and I was lucky enough to be hired as the in-house attorney in charge of architecting the portfolio. The company had various technologies such as, number one, scanning of your teeth. Number two, a computer-aided design where they took the scan model and then they can create treatment paths for you. And then number three, the device is to fabricate this using 3D printing. And we patented all of those aspects, and then we also patented the whole system level. So that was an exciting time in the year 2000 that I was involved with Invisalign. Today, there are many companies that make invisible dental treatment devices. But 20 years ago, there was a unique company called Align Technology that made the Invisalign system. They pioneered the concept of using invisible appliances that would apply pressure to move your teeth to perform orthodontic treatment. And that revolutionized the industry.